What happens if you're married and don't have a clear estate plan? Being married doesn't always guarantee legal protection unless your estate plan says so. I'll be sharing 7 things every couple needs to know about estate planning, whether you've been married 30 years or just tied the knot. Hi, I'm Dr. Ray Gervasio. In 30 years as an attorney, I've seen families torn apart, wealth drained, and years wasted in court, all because of poor planning. We make sure that doesn't happen. If you want to protect what you've built and keep your family out of court, call us at 408-945-3950 for an initial consultation. Let's start with the first point. Number 1. Unmarried couples are not protected by default laws. Many couples assume that being in a long-term relationship offers legal protection, but in California, unmarried partners have no automatic rights. If one partner becomes incapacitated or dies without an estate plan, the other may have no legal authority to access accounts, make medical decisions, or remain in the shared home. In some cases, surviving partners are excluded entirely, especially when family members don't acknowledge the relationship. Even married couples shouldn't assume everything automatically goes to a spouse. Blended families, separate property, or outdated documents can complicate matters. Without a clear plan, the law decides who gets what, and it may not reflect your wishes. Number 2, power of attorney is essential for all couples. Being married doesn't automatically give your spouse the authority to act for you if you become incapacitated. In fact, without a valid power of attorney, your spouse may have to go to court to make financial or medical decisions on your behalf. This can be a painful process during an already stressful time, and it gets even more complicated if your family members disagree about what should happen. A durable power of attorney for finances allows your spouse or someone you trust to manage your account, pay bills, and handle business affairs if you're unable to. A healthcare directive ensures that medical providers know who can speak for you and what your wishes are regarding treatment, resuscitation, and end-of-life care. These documents give peace of mind and make sure the person you trust most is the one making decisions, not the courts or a distant relative. Number 3, prenups and postnups can impact your estate planning. If you and your spouse have a prenuptial or postnuptial agreement, it can directly affect how your assets are distributed after death. These agreements often outline how property is classified, like what's considered separate versus community and who has a claim to it. If you create a trust or a will without considering the terms of your prenup or postnup, you could accidentally create a conflict or even invalidate part of your estate plan. This is especially important in second marriages or blended families where protecting children from a previous relationship is a priority. Prenups and postnups can provide structure and clarity, but they need to be coordinated with your estate documents to avoid confusion. The same goes for business interests. If you're a business owner and your prenup limits what your spouse can claim, that needs to be reflected in your succession planning. Number 4, estate planning is about more than assets. Many couples think estate planning is just about who gets what, but it's really about value, clarity, and protection. Yes, it includes dividing assets, but it also answers bigger questions. Who will raise your children if something happens to both of you? Who will make medical or financial decisions if you can't? How will your legacy continue through charitable giving, business succession, or education funds? Estate planning gives your family guidance when they need it most. It reduces stress, prevents conflict, and ensures your wishes are followed, even if you don't think you have a lot. Having a plan means protecting your loved ones and avoiding legal complications down the road. Number 5, newlyweds don't automatically inherit from each other. In California, your spouse may inherit from you if you die without a will, but it's not always as straightforward as people think. If you have separate property or things you own before you marry or receive as a gift or inheritance, it doesn't automatically go to your spouse. If you have children, parents, or siblings, they could have a claim under California's intestate succession laws. Let's say you own a home together, but your name is the only one on the title. Without a proper estate plan, your spouse might not automatically get the house. They could end up in a long, expensive probate process just to stay in the home you both lived in. Getting married is a great time to review your estate documents, update beneficiaries, and make sure everything reflects your current wishes. It's also a good moment to plan together, to talk through what you both want and build a unified approach to your future. Number 6, planning protects blended families. Blended families can bring a bit of complexity to estate planning. If you have children from a prior relationship, you may want to protect their inheritance while still providing for your current spouse. Without clear instructions, that balance can easily be lost. Default laws often favor the surviving spouse, which can unintentionally disinherit children from a previous marriage. A trust-based estate plan allows you to divide assets thoughtfully, support your spouse, and preserve inheritance for your children. You can even set staggered distributions or create separate trusts to reduce confusion. The goal is to protect everyone you care about and prevent conflict down the line. Number 7, start early and update often. Estate planning isn't a one-time event. It's something you revisit as your life changes. Marriage, kids, career moves, new homes, health changes. All of these moments are opportunities to update your estate plan. At a minimum, review your estate plan every 3 to 5 years. Update it after any major life events, and make sure your loved ones know where to find the documents when the time comes. Starting now doesn't mean you have to get everything perfect. It just means you're thinking ahead. And that simple act can save your family months or even years of heartache and confusion. Being married doesn't replace a will or a trust. Remember, estate planning is still essential, especially if you have kids, property, or previous marriages. If you haven't started your estate planning yet, or if you need to review your existing plan, give us a call at 408-945-3950 for an initial consultation. We'll guide you through the process and help you create a plan that fits your needs. And if you found this video helpful, don't forget to hit the like button and subscribe. I'll see you in our next video.